The judge had already made up her mind before my attorney stood up. I could see it in the way she glanced at me: blue denim jacket, work boots, silver hair that needed trimming. She saw a retirement-age man who looked like he fixed things for a living and assumed I was the one hiding something. She was right about the hiding. She was wrong about who was hiding what. That morning, my wife of 22 years had told the court I owned a small landscaping business and a house with a mortgage. What she did not tell the court, and what the judge did not know, is that I also owned 12 commercial properties across 3 counties, including the Mall, where my wife's divorce attorney leased his office. My name is Thomas Rourke. I'm 67 years old. I own a 7-year-old pickup, a small ranch house with a garage that needs painting, and 12 commercial properties across 3 counties. For 38 years, I built that portfolio one lease at a time while wearing the same kind of work jacket the judge dismissed in 30 seconds flat. This is not a story about revenge. It's about what happens when the legal system mistakes quiet for weakness, when a spouse assumes simplicity means poverty, and when a courtroom full of professionals discovers they've been outmaneuvered by a man who looks like he fixes parking lot lights for a living. Because sometimes I do, and sometimes I own the parking lot. I bought my first commercial property in 1986. I was 29 years old, working 6 days a week running a landscaping crew for office parks and strip malls, and I had saved $53,000 living in a 1-bedroom apartment above a dry cleaner. The property was a small auto repair garage on the edge of town. The owner was retiring, the building needed a new roof, and the bank told me I was too young and too undercapitalized to qualify for a commercial loan. I found a credit union that disagreed. I put down 40%, fixed the roof myself over 6 weekends, and signed a 10-year lease with a mechanic named Saul who still runs his shop there today. That was property 1. By the time I met Deborah at a Chamber of Commerce mixer in 1997, I owned 4. By the time we married in 1999, I owned 6. She knew I had a landscaping business because that was the company I brought her to the event with. She knew I owned a house because she moved into it. She did not know about the commercial holdings because I never mentioned them, and I never mentioned them because I had learned something early from a mentor who owned a chain of hardware stores. He told me once, "Thomas, the moment people know what you have, they start making plans for it." I took that seriously. Deborah and I had a good marriage for a long time. She was warm, capable, and she liked the quiet life we built. I was gone early mornings managing crews, but I was home for dinner most nights, and on weekends we drove to estate sales or worked in the garden. She asked me once early on why we lived so modestly when the landscaping company had such steady contracts. I told her I like to keep things simple. She accepted that. For 15 years, that answer was enough. Then something shifted. It started small, a comment about the truck. A comment about the kitchen cabinets that needed refinishing. Then a comment about how her sister's husband had just bought a second home in Florida, and wasn't it nice that some people planned for the future. I told her we were comfortable. She said comfortable was a word people used when they didn't want to say exactly how comfortable. I didn't correct her. In 2014, I bought a strip mall in the next county over. 6 retail units, a laundromat, and a pizza place with a lease that had 12 years remaining. I paid cash from the accumulated rents of the other properties. I drove home in the same pickup truck with a crack in the windshield, and I watched Deborah look at that crack when I pulled into the driveway. She didn't say anything. She just looked at it. By 2017, she had stopped asking about the finances entirely. She had started asking other things, whether I was happy, whether I felt like I had done everything I wanted to do, whether I ever thought about what would happen if something happened to me. I told her I had a will. I told her everything was taken care of. She nodded and went back to her book. I now understand that was the moment she stopped believing me. The divorce papers arrived on a Thursday in March of 2022. I was underneath the kitchen sink, fixing the garbage disposal. I heard the doorbell, wiped my hands, and signed for a certified letter. I opened it standing at the front door while the delivery driver waited for his electronic signature. The petition stated that Deborah Rourke sought dissolution of marriage on grounds of irreconcilable differences. It listed her attorney as Martin Drescher of the firm Drescher and Hale. It further stated that the petitioner believed the respondent, that was me, was concealing marital assets and requested full forensic discovery. The word concealing was underlined in my mind for the rest of the day. I called Howard that evening. Howard Bellamy has been my attorney for 26 years. He is 71 years old, wears suspenders, and has never lost a property dispute in 3 decades of practice. I told him about the petition. He asked me 2 questions. 1, had Deborah ever been listed as a co-owner on any of the commercial properties? I said no. 2, had she ever been present when I discussed the properties with Howard or anyone else? I said no. He was quiet for a moment. Then he said, "Thomas, she's going to ask the court to find assets you've supposedly hidden. What she doesn't know is that the assets are real. They're just titled in ways she never bothered to learn about. That puts her in a very dangerous position legally." A petitioner who accuses a spouse of hiding assets and then omits those same assets from her own financial disclosure is potentially committing perjury. I asked him what he recommended. He said, "We do nothing yet. Let them file their discovery demands. Let them hire their forensic accountant. Let them build their case on the assumption that you're a simple landscaper with a modest house. And when they've committed to that narrative in court filings and depositions, we file a complete financial disclosure that itemizes 12 commercial properties held in 3 different LLCs and a trust your late mother's estate planning attorney would have admired." I asked him if that was legal. He said, "It's not only legal, it's what the rules require at the appropriate time. You're not hiding anything, you're just not volunteering it before you're asked." The first court appearance was in April. Family Court, Division 4, Judge Marion Whitfield presiding. Judge Whitfield is a woman in her late 50s with a reputation for efficiency and a low tolerance for what she calls litigant gamesmanship. She has handled hundreds of divorce cases. She has seen husbands try to hide money in cryptocurrency, in shell companies, in their mother's bank accounts. She has developed, according to Howard, a finely tuned instinct for who is lying and who is not. When I walked into her courtroom wearing a clean but worn denim jacket and work boots I had polished the night before, she glanced at me over her reading glasses. Her expression did not change. I have been underestimated my entire life. I recognized the look. Deborah sat at the plaintiff's table with Martin Drescher, a man in a suit that cost more than the transmission repair I had paid for the month before. Deborah looked at me once and then looked away. She was wearing a new watch. The hearing was procedural: temporary support, discovery timelines, mediation referrals. Deborah's financial affidavit listed her income as a part-time bookkeeper at $22,000 a year. It listed the marital home with an estimated value of $240,000 and a remaining mortgage of $87,000. It listed my landscaping business with an estimated annual income of $60,000. It did not list 12 commercial properties, 31 rental units, or the strip mall with the pizza place that had 2 years left on a triple net lease. Howard filed an answer that admitted only what was required. He did not correct her affidavit. He did not supply a counter-disclosure. He simply wrote, "Respondent denies the allegation that he has concealed marital assets and reserves the right to present a complete financial statement at the appropriate juncture." Judge Whitfield set temporary support at $2,500 a month based on the $60,000 income figure. I paid it every month on the 1st. The forensic accountant Drescher hired was a woman named Cynthia Voss. She had a reputation for being thorough. Howard had faced her in 2 prior cases and described her as a bloodhound with a spreadsheet. She sent a document request that ran 17 pages. Bank statements, tax returns, business records, credit card statements, vehicle titles, property deeds, insurance policies, records of any safe deposit boxes, records of any trusts, records of any transfers exceeding $5,000 in the preceding 7 years. Howard responded with a partial production that included the landscaping business records and the personal accounts. He did not include the LLC records or the trust documents because the request did not specifically ask for them by name. Cynthia Voss followed up with a second request demanding disclosure of all business entities in which I held an interest. Howard waited the full 30 days the rules allow before responding. He sent a letter listing 3 LLC names: Rourke Commercial Holdings 1, Rourke Commercial Holdings 2, and a third entity called Westbrook Properties LLC, named after the street where my mother grew up. He attached no financial statements. He simply confirmed the entities existed. That was in June. For the next 6 weeks, nothing happened. The discovery process ground forward. Cynthia Voss requested the operating agreements for the LLCs. Howard provided them. They showed me as the sole member. They did not show the underlying property holdings because operating agreements do not list assets. They govern management structure. Deborah's side grew frustrated. Martin Drescher filed a motion to compel, alleging that I was stonewalling. Judge Whitfield set a hearing for September. That hearing is where everything changed. The morning of September 14th, I dressed the same way I always dress. Work pants, a button-down shirt, the denim jacket my son gave me for Christmas 6 years ago. I met Howard in the courthouse parking lot at 8:15. He was holding 2 leather folders. He handed me one and kept the other. We walked into Division 4 together. Deborah was already seated with Drescher. Cynthia Voss was in the gallery with a cart of document boxes. The judge entered and took the bench. She looked directly at me and said, "Mr. Rourke, your attorney has been less than forthcoming about your financial affairs. I am running out of patience. If I find that you have been hiding assets, I will not hesitate to impose sanctions, including but not limited to awarding the entirety of any concealed assets to Mrs. Rourke and referring this matter to the district attorney for perjury investigation." "Do you understand me?" I said. "Yes, Your Honor." Howard stood up. He said, "Your Honor, my client is prepared to provide a complete financial disclosure this morning. We have been awaiting the appropriate moment to ensure that all information is presented accurately and in context." The judge looked skeptical. She said, "I will take a 15-minute recess. When I return, I expect a document that lists every asset Mr. Rourke owns, free and clear of any further delay." She banged her gavel and left the bench. Howard turned to me. He opened his folder. He said, "It's time." And that's when I saw Deborah look at me from across the room. Not with anger, with the first flicker of something she had not felt in a very long time: uncertainty. Howard stood and walked toward the court clerk with a document that was 11 pages long. The recess had lasted 19 minutes. Judge Whitfield had taken her seat. The courtroom was silent except for the air conditioning and the sound of Cynthia Voss moving one of her document boxes a few inches to the left. The clerk stamped the filing and handed a copy to the bailiff, who walked it to the judge's bench. Howard returned to our table and did not look at me. He didn't need to. We had been waiting for this moment since the petition arrived. The judge put on her reading glasses and began to scan the first page. I watched her face. I had learned to read faces over 38 years of commercial lease negotiations, and I read hers now the way I read a prospective tenant's when they first saw the rent schedule. She turned to page 2. Her lips parted slightly. She turned to page 3. Her hands stopped moving. She looked up over her glasses at Howard. She said, "Mr. Bellamy, is this document complete and accurate to the best of your client's knowledge?" Howard said, "It is, Your Honor. We have attached supporting property deeds, LLC operating agreements, trust instruments, and 3 years of tax returns for each entity. The summary sheet on page 1 provides a consolidated view, but the detail follows in the subsequent pages." The judge turned back to the document. She turned to page 4, page 5. The courtroom was so quiet I could hear the bailiff shifting his weight in his chair. Deborah was looking at Martin Drescher. Drescher was looking at the back of the judge's bench as if he could see through the wood into the document. Cynthia Voss had stopped moving her box. The judge reached the final page and set the document flat on the bench. She removed her glasses. She said, "Mr. Drescher, have you seen this filing?" Drescher stood. He said, "No, Your Honor, we have not been provided a copy." The judge gestured to the clerk, who made a copy and handed it to him. Drescher took it and began to read. I watched him read the same way I had watched the judge read. Page 1, page 2, page 3. His expression did not collapse dramatically. It tightened. The color in his face shifted from courtroom pale to something duller. He reached page 5 and his hand stopped moving. He looked up at Deborah. Deborah looked back at him, not understanding. The judge waited. She said, "Mr. Drescher, are you aware that your client's financial affidavit filed with this court on April 19th of this year listed the marital estate as comprising a primary residence with approximately $153,000 in equity and a landscaping business generating $60,000 in annual revenue?" Drescher said, "I am aware, Your Honor." The judge said, "Are you further aware that the financial disclosure just filed by the respondent lists 12 commercial properties held across 3 limited liability companies and 1 revocable trust, with a combined estimated value of $4.7 million, generating annual rental income in excess of $340,000. The number landed in the room like a dropped weight. $4.7 million, $340,000 a year. Deborah's head turned from Drescher to me and back to Drescher. She opened her mouth and closed it. The judge did not look at her. She was looking at the document again, flipping back to page 1. She said, "Mr. Drescher, your client is the petitioner in this matter. She initiated this divorce. She filed an affidavit under penalty of perjury stating that she was not aware of any assets beyond those she listed. Yet the respondent, in response to a motion to compel filed by your office, has now produced documentation of 12 commercial properties, 31 rental units, and income streams that exceed $300,000 annually. Some of these properties were acquired during the marriage. Your client has lived with the respondent for 22 years. Would you care to explain how she was unaware of any of this?" Drescher stood very still. He was a skilled attorney. He had been doing this work for decades. He understood that he had just been handed a problem he could not fix with emotion. He said, "Your Honor, I would request a brief continuance to confer with my client before responding." The judge said, "Denide, your client is under oath. Mrs. Rourke, please stand." Deborah stood. She was gripping the edge of the table. Her knuckles were white. The judge said, "Mrs. Rourke, you have heard what I just described. You have lived with Mr. Rourke for 22 years. You are the petitioner in this action. You filed an affidavit swearing that the assets listed in your disclosure represented the full extent of the marital estate to your knowledge. I am asking you directly, did you know about these commercial properties?" The courtroom was suspended. Deborah looked at me. I did not look away. I did not smile. I simply waited. She said, "I knew he had a landscaping business. I knew he worked a lot. He never talked about money. He never." The judge cut her off. "Mrs. Rourke, I did not ask what he told you. I asked what you knew." Deborah's face was doing something complicated. It was not simply the look of someone caught. It was the look of someone recalculating 2 decades of assumptions in the space of 5 seconds. Every modest house, every worn jacket, every time she had asked about money and I had said we were comfortable. She said, "I didn't know the details." Judge let the silence sit. Then she said, "Mrs. Rourke, this court takes perjury extremely seriously. If I determine that you knowingly omitted assets from your financial affidavit, I can refer this matter to the district attorney for criminal investigation. I can also award attorney's fees to Mr. Rourke for the cost of defending against an accusation you yourself may have known to be unfounded. Do you understand?" Deborah's voice was very small. "I understand." The judge turned to Drescher. "Mr. Drescher, your office filed a motion to compel alleging that the respondent was concealing assets. That motion is now resolved. The respondent has disclosed assets that exceed the marital estate as described by your client by a factor of approximately 20. I will give you 1 week to file an amended financial affidavit on behalf of Mrs. Rourke that reflects full knowledge of these assets. If that affidavit is not filed, or if I find it to be incomplete, I will hold Mrs. Rourke in contempt. Is that clear?" Drescher said, "Yes, Your Honor." And then the judge looked at me. Her expression was not warm, it was professional, but it had shifted. The man in the denim jacket had just done something she had not seen coming, and she was a woman who had seen nearly everything. She said, "Mr. Rourke, I owe you an acknowledgement. I assumed certain things about your financial situation based on your appearance and your attorney's measured pace of disclosure. I should not have done so. The court apologizes." I said, "Thank you, Your Honor." She said, "This matter is continued for a settlement conference. I expect both parties to negotiate in good faith now that the full picture is on the table." She banged her gavel and left the bench. The courtroom exhaled. Howard closed his folder and stood. I stood with him. Deborah was still standing at her table. Drescher was speaking to her in a low voice, but she was not listening to him. She was looking at me. She walked toward our table. Howard stepped slightly forward, not blocking her but present. She stopped 2 feet away. She said, 22 years, Thomas. 22 years you let me believe we were just getting by." I said, "I never told you we were getting by. I told you we were comfortable." She said, $4.7 million is not comfortable. It's wealthy. I bought generic groceries. I clipped coupons. I drove the same minivan for 11 years. I said, "I drove the same truck for 15. The difference is I knew why I was driving it." She looked at me for a long moment. She said, "Was any of it real?" I thought about that question. I thought about the garden we planted together, the 17 Thanksgivings we hosted. The week she stayed up all night when I had pneumonia. I said, "It was all real. The money was just a number. You were the one who made it mean something else." She did not answer. She turned and walked back to her table. Howard and I left the courtroom together. In the hallway, Cynthia Voss was packing her document boxes onto a wheeled cart. She looked at Howard. She said, "You sandbagged me." Howard said, "Cynthia, you sent a discovery request. We answered it. You didn't ask the right questions. That's not sandbagging, that's law." She shook her head and pushed her cart toward the elevator. We walked out into the September sunlight. The courthouse plaza was empty. Howard unbuckled his leather folder and handed me a second document, a single sheet. He said, "There's one more thing you should know before the settlement conference." I looked at the sheet. It was a list of the commercial tenants in the properties I owned. The first property, the auto repair garage Sal's shop. The second, a small office building with a dentist and an insurance agency. The third, a retail strip with a dry cleaner. I scanned down the list. I stopped at property number 7, Westbrook Crossing Shopping Center, 6 retail units, a laundromat, a pizza place, and 1 professional office suite. The professional office suite was leased to Drescher and Hale, attorneys at law. Martin Drescher, the man who had filed the motion to compel, who had accused me of concealing assets, who was representing my wife in a divorce that sought to uncover hidden wealth, rented his law office from me. His lease had been in effect for 8 years. He paid me $3,200 a month for 1,200 square feet of prime retail frontage. I had been his landlord the entire time the divorce was being litigated, and neither of us had known. I looked at Howard. Howard said, "I discovered it during the title search. I didn't disclose it during the hearing because I wanted to give you the option of how to handle it." I said, "Does Drescher know?" Howard said, "Not yet. His name is on the lease as the tenant, but the lease is held through his professional corporation. The signatory on the lease is a junior partner who signed on behalf of the firm. Drescher himself may never have seen the property owner's name. It's an LLC. He has no reason to associate with you." I stood on the courthouse plaza holding a piece of paper that made my wife's divorce attorney my tenant. The divorce had been contentious. It had been expensive. My wife had accused me of hiding assets. Her attorney had filed motions suggesting I was a liar. And now I was holding evidence that the attorney himself paid his rent to an entity I controlled. The conflict of interest was not theoretical, it was structural. If Drescher continued to represent Deborah after learning he was my tenant, he would be in violation of at least 2 Bar Association ethics rules. If he withdrew from the case, Deborah would need to hire a new attorney, restart discovery, and pay a new retainer on a case that had already cost her tens of thousands of dollars. And that was before we discussed the perjury referral. I folded the paper and put it in my jacket pocket. Howard asked me what I wanted to do. I said I needed to think about it. I said I wanted to see what Deborah did next. Because the divorce was no longer about money. The money had been disclosed. The money was mine, protected by legal structures that had been in place for years, never hidden, simply never discussed. The divorce was now about what people do when the story they told themselves collapses. And there were 3 people who had told themselves stories that were about to come apart. Deborah, who had convinced herself she was divorcing a modest landscaper. Martin Drescher, who had built a case on the assumption that I was hiding assets. And Judge Whitfield, who had looked at my denim jacket and made a ruling about my character before I ever opened my mouth. The settlement conference was scheduled for October 3rd. That gave Deborah 21 days to file an amended affidavit. That gave Drescher 21 days to discover who his landlord actually was. And that gave me 21 days to decide exactly how much of the truth I wanted to share and with whom. I drove home in my pickup truck with a crack in the windshield. The same truck Deborah had looked at with quiet disappointment for years. I parked in the driveway. I walked into the house and stood in the kitchen where 22 years of meals had been made. The silence was different now. It wasn't the silence of 2 people who had stopped talking. It was the silence of a man alone in a house he was about to keep or sell or something in between, standing in the space where his wife had once asked him if he was happy and he had not known how to answer. I made coffee. I sat at the kitchen table. I unfolded the paper Howard had given me and read it again. Westbrook Crossing Shopping Center, Unit 106, Drescher and Hale, attorneys at law, $3,200 a month. The next rent payment was due in 5 days. And that detail, that small procedural fact, was about to become the lever that flipped this entire case on its head. I called Howard the next morning and asked him one question. What happens if Drescher pays his rent on time? Howard said, then nothing happens yet. He pays rent to the LLC. The LLC receives the funds. The transaction is ordinary. The conflict of interest is not triggered until someone with standing raises it, which is you. I asked him if I should raise it. Howard was quiet for a moment, the way he gets quiet when he is measuring the distance between what the law allows and what his client actually wants. He said, Thomas, you are not obligated to inform opposing counsel that he is your tenant. You are obligated not to use that fact to gain an unfair advantage in litigation, but the fact itself is already in the financial disclosure. When the full asset list is reviewed, your LLC's tenant roster will be discoverable. It will come out. The question is simply when. I told him I did not want to ambush a man in open court if it could be avoided. Howard said, "That is a sentiment the judge will appreciate." I said, "Then let's make sure it comes out before the settlement conference. Send a courtesy letter to Drescher's firm, inform them of the landlord-entity structure, keep it professional, let them decide what to do." Howard said he would draft the letter that afternoon. I hung up and went to work. I had 31 rental units across 12 properties, and somewhere in the middle of a divorce that had turned into a financial autopsy, the drains still clogged, the roof still leaked, and the tenants still called. I spent the morning at the auto repair garage, the first property I ever bought, where my tenant Saul showed me a crack in the foundation that had grown an inch in the past year. I told him I would get an engineer out. Saul asked me how the divorce was going. I told him it was expensive and complicated and that I would rather be fixing a foundation. He laughed and offered me a cup of coffee from the same machine he had used since 1988. That afternoon, I drove to Westbrook Crossing Shopping Center. I parked in the lot and walked the sidewalk past the pizza place, past the laundromat, past the unit with the frosted glass door that read Drescher and Hale, attorneys at law. I had been in that building dozens of times over the years. I had replaced the HVAC unit in 2014. I had negotiated the lease renewal with a junior partner in 2019. I had never once connected the name on the lease to the man who stood across from me in a courtroom and told the judge I was hiding assets. I stood on the sidewalk and I looked at that frosted glass door, and I felt something I did not have an immediate name for. It was not anger. It was not satisfaction. It was the odd, particular feeling of a system working in a way no one involved had consciously designed. Drescher had chosen to take my wife as a client. He had chosen to file a motion accusing me of concealment. He had done those things while occupying a space I owned. The gears had been turning the entire time, silently, beneath everything. I got back in my truck and drove home. The letter went out the following day, sent by certified mail to the firm's business address. That was September 20th. The rent payment from Drescher and Hale cleared the LLC account on September 21st, as it had every month for 8 years. The settlement conference was October 3rd. What happened in the 13 days between that rent payment and that conference is still, in some measure, a thing I am piecing together from what people told me later. I know that Howard's letter arrived at the firm on September 22nd. The receptionist signed for it. It sat on the desk of the managing partner, a man named Gerald Hale, for 2 days while he was in depositions in another county. He opened it on September 24th. He read it. He called Martin Drescher into his office and closed the door. According to what Howard later learned from Hale's own attorney, Drescher's reaction was immediate and physical. He stood up, walked to the window, and stood there for nearly a full minute without speaking. Then he said, and this is a quote Howard shared with me during a phone call that weekend, "Jerry, I just filed a motion in family court accusing my own landlord of hiding assets from his wife, and I signed that motion on letterhead that lists this office's address, an address I rent from him." Hale spent the next 48 hours consulting with the firm's ethics counsel and its malpractice carrier. The conclusions were unanimous. Drescher could not continue to represent Deborah Rourke in a matter where he had an undisclosed financial relationship with the opposing party. Even if the relationship was indirect, even if he had been unaware, the conflict was non-waivable. Drescher would need to withdraw, the firm would potentially need to refund legal fees, and Deborah Rourke would need to retain new counsel in the middle of a divorce that had just exploded. I learned all of this on September 27th when Howard called me from his car. He said, "Drescher's office filed a motion to withdraw this morning. The hearing is set for September 29th. Judge Whitfield is going to see that motion and the reason for it at the same time she sees Deborah's amended financial affidavit, which, by the way, still hasn't been filed." I said, "She's late." Howard said, "She is very late. The deadline was September 26th. She has not requested an extension." The hearing on September 29th was short and devastating. Howard attended. I was not required to be there, but I went, and I sat in the back of the gallery in the same denim jacket because I wanted to watch, not to gloat. I wanted to see how the system handled itself. Drescher stood before Judge Whitfield and asked permission to withdraw as counsel of record. He cited irreconcilable conflicts that had come to his attention following the respondent's recent financial disclosure. He did not specify what the conflict was, but the judge is not a woman who lets things go unspecified. She asked him directly, "Is this conflict financial in nature?" Drescher said, "It is." She asked, "Is it the result of a relationship between your firm and the respondent or any entity the respondent controls?" Drescher said, "Yes, Your Honor." The judge opened the file in front of her. She leafed through the asset disclosure I had filed 2 weeks earlier. She turned to the page listing the tenants of Westbrook Properties LLC. She read it in silence. She looked up. She said, "Mr. Drescher, your law firm leases office space from an entity wholly owned by the respondent. Is that correct?" Drescher said, "It is, Your Honor. I was not personally aware of the ownership structure until this week. The managing partner received a courtesy notice from Mr. Bellamy's office." The judge looked at Howard. Howard stood and said, "Your Honor, as soon as my client realized the connection, he instructed me to notify opposing counsel. We provided the notice on September 20th. The purpose was to ensure that any conflict could be addressed transparently before the settlement conference." The judge turned back to Drescher. She said, "You are aware that your firm's lease constitutes a financial relationship with the opposing party that you failed to discover for the entirety of this litigation?" Drescher said, "I am." She said, "Motion to withdraw is granted. Mrs. Rourke, you have 30 days to retain new counsel. The settlement conference is vacated. I am rescheduling it for November 15th, and I am ordering that by that date, an amended financial affidavit shall be filed that reflects full knowledge of the respondent's assets. The fact that your attorney must withdraw does not relieve you of your obligation to be truthful about what you knew and when you knew it. Do you understand?" Deborah stood. Her face was pale. She said she understood. But that was not the end of the hearing, because after the judge ruled on the withdrawal, Howard stood again and said there was another matter. He had conducted a review of the properties listed in the disclosure to determine their classification as marital or separate property. He requested permission to file a brief summarizing the findings in advance of the rescheduled settlement conference. The judge granted it. What Howard filed 3 days later fundamentally altered the math of this divorce. You have to understand something about how I built what I built. The first 4 properties I owned were purchased before I met Deborah. The auto garage in '86, a small office building in '89, the retail strip in '92, a warehouse in '95. They were titled in my name individually, then transferred into Rourke Commercial Holdings 1 LLC in 1998 before the marriage. The next 2 properties were purchased in 2001 and 2004 after the marriage, but the funds used to buy them came from the rental income of the premarital properties. Under state law, income from separate property remains separate property if it can be traced. Howard had 37 years of bank statements showing exactly that trace. Every dollar that bought the later properties came from the earlier ones. The next 4 properties were placed directly into a revocable trust established by my mother's estate plan, the details of which named me as trustee and beneficiary, but structured the ownership such that the trust corpus is not considered marital property under the Equitable Distribution Statute. The final 2 properties, including Westbrook Crossing, were titled in Westbrook Properties LLC, an entity whose operating agreement explicitly restricts transfer of membership interests and limits ownership to me as sole member, with a buy-sell provision triggered upon any claim of marital interest. The provision states that any attempted transfer to a non-member spouse triggers a right of first refusal at a price determined by the LLC's own valuation formula, which is based on taxable assessed value, not market value. Deborah's claim to any portion of those assets had just been reduced to a fraction of what she had believed 3 weeks earlier. When Howard's brief was filed, the effective value of the marital estate was reclassified. The primary residence had approximately $153,000 in equity. The landscaping business was valued at roughly $80,000. The marital portion of the commercial portfolio, after tracing analysis and trust protections, was estimated at 0. Deborah stood to receive half of the house equity and half of the landscaping business, roughly $116,500 total, less than a third of what she had already spent in legal fees. The woman who had filed for divorce expecting to uncover hidden millions had just learned that the millions were real but unreachable, and that she had accused a man of concealment who had simply never corrected her assumptions while building a legal architecture that predated her by a decade. I did not enjoy this realization. I watched it happen from a distance, through filings and phone calls and the measured voice of my attorney, and I felt something closer to exhaustion than to victory. The 12 days before the rescheduled settlement conference were quiet. Deborah's new attorney, a woman named Elena Ruiz, filed an entry of appearance and requested an extension of time to review the voluminous financial records. That was granted. She also filed a motion asking the court to reconsider the tracing analysis, arguing that commingling had occurred and that certain funds had been used for marital expenses. That was scheduled for argument at the November conference. But the central fact did not change. The properties were there, the trusts were there, the LLC was there, the protections were ironclad, and somewhere in the middle of that quiet on a Tuesday morning in early October, I got a call from my son. Nathan is 34. He lives in Austin with his wife and 2 daughters. He knows about the properties. He has known since he was 25, when I sat him down at the same kitchen table and walked him through everything. He called and said he had heard from his mother. They still talk. She told him what was happening. He said, "Dad, she's scared." I said I knew. He said, "Is it true what she's telling me, that she can't get any of it?" I told him it was true in the legal sense, that the assets were protected because I had planned them that way, and I had planned them that way because his grandmother, my mother, had grown up with nothing and drilled into me that you protect what you build. I told him I had never intended for his mother to be left with nothing. I said she had brought this on herself by filing a false affidavit and building a case on an assumption she never checked. He was quiet. Then he said something I will not forget. He said, "Dad, did you ever love her enough to tell her the truth?" I sat with that question for a long time after the call ended. I sat in the kitchen where 22 years of meals had been made, and I thought about the garden and the Thanksgivings and the week she stayed up all night when I had pneumonia. And I realized that Nathan's question was the one the court would never ask, not because it wasn't important, but because the law does not measure love. It only measures what can be proved, and what I could prove is that I had never lied. What I could not prove, what I was only beginning to understand myself, was whether a marriage built on comfortable silence was fundamentally different from one built on comfortable lies. The rescheduled settlement conference was November 15th. I walked into Division 4 wearing a clean shirt and the same denim jacket, and I was ready to end this thing. But the ending was not going to happen the way anyone expected, because Deborah's new attorney had done something no one saw coming. Elena Ruiz had found the one crack in the foundation, not a legal crack, a factual one. In 2003, 6 years into the marriage, I had paid off the remaining mortgage on the house using $41,000 from a joint checking account. The account had been funded primarily by my landscaping income, which was marital income. But the house, which I had owned before the marriage, had been titled solely in my name. Under the tracing analysis Howard prepared, the house was my separate property. But the $41,000 of marital funds used to satisfy the mortgage created what the law calls a transmutation claim, a claim that the asset had been partially converted into marital property through the contribution of shared money. It was not a large crack. It did not open the door to the commercial properties, which Howard's brief had effectively walled off, but it meant Deborah's claim to the house was not zero. It meant she could argue she was entitled to reimbursement of the $41,000 plus appreciation, which, given the increase in neighborhood values, was now closer to $90,000. And Elena Ruiz had backed that claim with bank statements Deborah had kept in a file box in her sister's garage. Statements I did not know she still had. The settlement conference on November 15th began with that claim. Howard and I had reviewed it the week before. He told me the law was on Deborah's side on this one point. He also told me the optics of fighting it would be terrible. A man with $4.7 million in assets arguing over $90,000 with a wife who had clipped coupons for 22 years. I told him I was not going to fight it. I told him to offer her the full amount plus $20,000 for her legal fees. He asked me if I was sure. I said I was. The conference room was on the 3rd floor of the courthouse, not the courtroom, a long table with windows overlooking the parking lot. Judge Whitfield sat at the head. Deborah sat with Elena Ruiz, a sharp woman in her 40s who had clearly spent the past month reading every document I had ever filed. I sat with Howard. The judge opened with a question she directed at Deborah. "Mrs. Rourke, your new counsel has filed a compelling argument regarding the marital home. Do you understand that this claim does not extend to the commercial properties?" Deborah said she understood. The judge then asked her the question that had been hanging over the entire case. Mrs. Rourke, in your original financial affidavit, filed on April 19th, you stated under penalty of perjury that you were not aware of any marital assets beyond the primary residence and the landscaping business. You are now claiming that you knew about $41,000 in mortgage payments made from a joint account in 2003. That payment is documented in the very bank statements your new counsel has provided. So I am asking you one more time. Did you know about the $41,000 when you filed your original affidavit? Deborah looked at me. Then she looked at the judge. She said, I did. I was angry. I thought he was hiding things. I thought if I filed a clean affidavit, the court would believe me and force him to come clean. I didn't think it through. The judge set her pen down. She said, Mrs. Rourke, that is a confession to filing a false affidavit. I have the power to sanction you, to refer you for criminal investigation, and to dismiss your claims for equitable distribution. I'm not going to do any of those things today. Not because what you did is acceptable, but because this divorce has already been litigated at a cost that far exceeds the marital estate as originally described. I am going to give you and Mr. Rourke the opportunity to settle this matter now, and I will tell you both what I believe a fair resolution looks like. She paused. She looked at me. She said, Mr. Rourke, I'm not going to order you to pay anything beyond what the law requires. But I want to tell you something I have learned in 23 years on this bench. Divorce is not a math problem. It is a human problem that the law tries to solve with numbers. The numbers say you owe your wife very little. The human problem is that she spent 2 decades married to a man she did not fully know. You are not legally at fault for that, but you are connected to it. I listened. I thought about Nathan's question. Did you ever love her enough to tell her the truth? I said, Your Honor, I am prepared to make an offer. I offered Deborah the house free and clear, including the full equity of approximately $260,000 after market appreciation. I offered to pay her legal fees in the amount of $45,000, and I offered a lump sum of $75,000, which together with the house would give her roughly $380,000, enough to start over, not retirement wealth, but a foundation. The judge asked Deborah if she would accept. Elena Ruiz whispered to her. Deborah looked at me across the table. Her eyes were wet. She said, 22 years, Thomas, and you're giving me the house. I said, it was our house. I just held the title. She nodded. She said she accepted. The judge approved the settlement on the record. Howard drafted the agreement that afternoon. I signed it on November 16th. Deborah signed it on November 17th. The divorce was final on November 22nd. The week after the settlement, I got a call from Gerald Hale, the managing partner at Drescher's firm. He told me the firm would be vacating the office at Westbrook Crossing at the end of the lease term. He said the conflict had been too damaging. He asked if I would consider an early lease termination without penalty. I told him I would. I said I had no interest in punishing a tenant for something they did not know. He thanked me. I told him it was just business. He said it was more than business for him. I said I understood that, and I did. In December, I drove out to Westbrook Crossing to check on the property. The space was empty. The frosted glass door still read Drescher and Hale, attorneys at law, but the furniture was gone and the reception desk was pushed against the wall. I stood in the empty office and I thought about the motion Martin Drescher had filed in that room, on that letterhead, accusing me of concealment while the lease sat in a filing cabinet 3 feet from his desk. I did not feel satisfaction. I felt the weight of a system that works on paper but stumbles on people. A month later, in January, I received a letter from Judge Whitfield, not a court order, a personal note on her personal stationery. She wrote that in 23 years on the bench, she had never apologized to a litigant from the bench for an assumption she had made about their character. She wrote that my case had reminded her that the law is a set of tools and that tools can be used skillfully or poorly by lawyers and judges alike. She wrote that she hoped I would not hold her initial judgment against the court as an institution. I wrote back. I told her I did not hold anything against her. I told her I had been underestimated my whole life, and I had learned to use that assumption the way a carpenter uses a level to find out what was actually true. She wrote back one more time. She said, that is a good metaphor. I may use it in a speech I am giving to the State Bar Association in March. I laughed when I read that. I was still laughing when I folded the letter and put it in the folder in my desk drawer next to the summary sheet Howard had prepared a year ago. In February, Nathan came to visit with his daughters. They ran through the house the way children do, touching everything, asking about the old photographs on the mantle. Nathan stood with me in the kitchen, where the evening light came through the window the way it always had. He asked me if I was okay. I told him I was. I told him I had spent the past year untangling a knot I had tied myself a long time ago out of habit and caution, and something my mother had taught me about not showing your hand. He said he understood. He said he was glad it was over. I poured 2 cups of coffee. I sat down at the kitchen table. I told him there was something I wanted him to have, not someday. Now. I opened the folder and slid a document across the table. It was an amendment to the trust. Added Nathan as a co-trustee with full access to the records and a role in management decisions. I told him I should have done this years ago. I told him I was done waiting for the right moment. The right moment was the one you made. He read the document slowly. His jaw tightened, the small thing he has done since he was 12 years old. He said he did not know what to say. I said, "You don't have to say anything, just learn how it works. And when the time comes, you'll know what to do." He looked at me, he said, "Thank you, Dad." I told him he was welcome. I told him the properties were not the important part. The important part was that he understood what it took to build something and what it took to keep it. That was the thing I should have told his mother 22 years ago, and I had not, and I would spend whatever time I had left making sure I told it to him. The morning sunlight came through the kitchen window the way it always does at that hour. The same gold light. The same old table. The same man, 67 years old, with a cracked windshield and a denim jacket, and 12 commercial properties he had built one lease at a time. And across from him, his son, who finally knew everything. I looked at Nathan. I said, "There's one more thing you should know." He looked up. I told him about the empty office at Westbrook Crossing. I told him about Martin Drescher and the lease and the letter from Judge Whitfield. And then I told him the thing that still makes me shake my head when I think about it. The thing that proves the universe has a sense of humor if you pay attention long enough to see it. In February, I got a call from a commercial real estate broker representing a new tenant who wanted the vacant office, a law firm that was expanding into the county. They had seen the listing, liked the location, and wanted to negotiate a 5-year lease. The name of the new firm was Ruiz and Associates. Family law, the same Elena Ruiz who had represented Deborah in the final settlement. I said yes. I signed the lease on March 1st. So if you walk into Westbrook Crossing Shopping Center today, you will find a pizza place, a laundromat, 5 other tenants, and a family law office run by a woman who once sat across a conference table from me and argued that I owed my wife more than the law required. She was right about that. And now she pays me rent every month, on time, just like the last firm did. Life is not a story. It does not resolve neatly. But sometimes, if you build carefully enough and wait long enough, it settles into something that feels, if not exactly like justice, then something close to it. Balance. I'll take balance. I have thought a lot about what this story means. Not the story of the divorce or the courtroom or the empty office with the frosted glass door. The larger thing underneath it. I think it is about what we assume when we look at someone and we think we know what their life is worth. The judge assumed my denim jacket meant a fixed income. My wife assumed my silence meant poverty. Her attorney assumed my slow disclosure meant concealment. Every one of them was wrong in a different direction, and every one of them was wrong because they stopped looking too soon. That is not a moral failure unique to them. It is a human pattern. We measure people by the signals we recognize, and we miss the signals we don't. I am not innocent in this. I let the signals stay unclear. I told myself it was privacy. I told myself it was what my mother taught me, and some of it was. But some of it was something else, something I am still working to name. The distance between keeping things simple and keeping things hidden is not as wide as I wanted to believe. Nathan asked me if I ever loved Deborah enough to tell her the truth. I have not stopped thinking about that question. I think the answer is yes, I loved her. I think the harder truth is that I loved the quiet more. I loved the order of a life where no one asked me to explain myself. And that is not the same thing as honesty. It is just an easier version of it. If you are watching this and you are building something, whether it is a business or a portfolio or just a life that you want to protect from the noise of other people's expectations, I am not going to tell you to put everything on display. That was never the point. The point is to know the difference between protecting what you have built and hiding behind it. I spent 37 years building walls that turned out to be unnecessary because the people who mattered were never trying to tear anything down. They were just trying to understand what was inside. If I have one thing to offer from all of this, It is that the trust and the LLC and the careful structure are all tools. They are good tools. I am proud of them. But they are not a substitute for telling the people you love what your life actually looks like. That is a separate thing. That is the thing I am still learning. And I am 67 years old. So if you are younger than me, and I suspect most of you are, you have time, use it better than I did. Tell someone the truth. Not because you owe them an explanation, but because you owe yourself the chance to be known. That is the thing Linda would have said. She was always better at this than me. If you made it this far, I appreciate your time. I'm going to go fix that crack in my windshield now. I have been meaning to get to it for 3 years. Some things do change. If you want to see more stories about what happens when the quiet ones finally speak up, consider subscribing. There are more of us out there than you might think.